I would kindly ask the panelists for the first panel to take their seats if they're in the room. I see Jennifer, Miss Eve Lahaye, and Mr. Mark Drumble, please.
Ladies and gentlemen, if I could ask you to take your seats in order that we can proceed. I'm told I'm the boss now, so could you please be seated? And we will begin the panel on legacy, normative legacy. If I could ask for your cooperation, it will allow us some time for coffee. The more time we lose now, the less time for coffee. Perhaps that's an incentive. So I'm just going to start. Good morning, everyone. Mr. Prosecutor. Good morning, everyone. It's my pleasure to moderate this panel on the normative legacy of the ICTY. I am joined by very distinguished panelists. I'm sure many of them known to you, but I'm quickly going to introduce the panel, and we will move to our substantive topic. Let me begin with Mark Drumble, who is a professor at Washington and Lee University School of Law. He's also the director of the Transnational Law Institute. He has been a visiting professor at a multitude of institutions, from Oxford to the University of Melbourne, to the University of Ottawa, and to Trinity College, and many more. He is the author of commended and critically acclaimed texts in the field of international criminal law. Mark, welcome to the panel. On my far right, we are very honored to have Judge Vucinic with us today, who has a wealth of judicial experience here in Bosnia and Herzegovina. He has served in the courts of various parts of the country since 1993, and very significantly has been with the War Crimes Chamber of the Bosnia and Herzegovina court since 2005, so he will bring a wealth of expertise in that area this morning. To my immediate left, Jennifer Trahan, who is a professor at the New York Center for Global Affairs. She has lectured and written extensively in this field, including on the ICTY, the ICC, the Iraq High Tribunal, and the crime of aggression. And she has two really interesting digests on the law, case law of the ICTY and the ICTR. And last we have Dr. Yves Lahaye, who is a legal advisor at the ICRC and has been there since 2007. Before that, she spent 4 years as an associate legal officer at the ICTY. She has a doctorate in law from LSE and a master's in international relations and international law from the Graduate Institute of International Studies in Geneva. So a wealth of experience this morning to share on this particular topic. Judge Agius and I sat for 4 years together on the Popovich et al. Case at the ICTY, and it appears we have developed some level of synergy because his comments this morning replicated word for word what I was going to say by way of introduction to the topic. So I will simply move quickly to emphasize that perhaps one of the most unanticipated outcomes of Resolution 827 and the establishment of the ICT. Why was the turning point that it represented for international criminal justice and its remarkable effect that it has brought onto international law, institution building at the international level and the national level. And so in a far too limited period of time, we're going to look at this key legacy, the normative legacy of the ICTY. I'm going to jump right in because of our time constraints and begin with a panel conversation on the topic to be followed by a panel conversation with you. And we hope to, we may take a few minutes into the coffee break, but hope that we can have a good dialogue on this topic. Let me begin by turning to Eve to ask her to address what is, of course, one of the most significant aspects of this normative legacy, to tell us a bit about the ICTY legacy in terms of the reaffirmation, the clarification, and the development of international humanitarian law. Thank you.
Thank you. In the view of the International Committee of the Red Cross, the ICTY has really made a monumental contribution to the reaffirmation, the clarification, and the development of Ihl. The Security Council report accompanying the draft ICTY statute made it clear that the Tribunal was to apply rules of Ihl which are beyond any reasonable doubt part of customary international law. That was to make sure that every party in the that every person would be bound by the same amount, by the same law, and made sure that at the time of the commission of the offense, the violations was reflected in customary international law. This finding by the Security Council in its report was very much followed by the seminal interlocutory decision in the Tadic case back in October 1995, when the appeals chamber interpreted the Article 3 of the statute to mean that for violations to be prosecuted, it had first to be reflected as a customary rule in international humanitarian law, and that it needed also to entail in customary law the individual criminal responsibility of the perpetrator for that particular act. This aspect paved the way for the judges to identify which rule of Ihl are reflected in customary international law. Through this process, the case law of the Tribunal clarified a great number of Ihl principles and was also able to adapt some more traditional provisions of Ihl to modern conflict and battlefield realities. The unquestionable result of 20 years of ICTY case law is clearly the narrowing of the gap between Ihl rules applicable in international armed conflict and the rules applicable in non-international armed conflict. We could easily spend more than an hour discussing in details and arguing on the customary value of some of those findings, but I was given only a very few minutes, so let me just highlight a few selected examples of this major breakthrough in Ihl. The first groundbreaking finding by the ICTY was the recognition that war crimes could be committed by individuals in non-international armed conflict. In other words, that individuals do not only commit violations of domestic law when they fight during a non-international armed conflict, but they can engage their responsibility under international law for war crimes in non-international armed conflict. Another very important clarification contained in this interlocutory decision of October 1995 by the appeals chamber is what did we mean by a non-international armed conflict. The Geneva Conventions are actually silent on the definition of the concept. States couldn't agree back in 1949, and there is no definition of what we mean and when do we reach a non-international armed conflict. The great contribution of that first decision is to clarify when do we go from a situation of violence to the situation of a non-international armed conflict. The tribunal highlighted criteria on organization of armed groups and on the length and of the violence. And these criteria really are, it was the first institution to really be able to give a first definition of what a non-international armed conflict. But the tribunal didn't only help academics and judges, domestically and internationally, to figure out when do we go from a situation of violence to a situation of armed conflict, but also when we pass from a situation of non-international armed conflict to a situation of international armed conflict, and under what circumstances the intervention by a third state, what are the conditions and the impact of the intervention of a third state who would be supporting unarmed groups, and when do we have, in fact, the internationalization of the conflict as a whole as a result of a foreign intervention supporting an armed group in a non-international armed conflict. In the same vein, the case law of the tribunal has clarified the geographical scope of application of Ihl as well as the temporal scope of Ihl. And by that I mean, where does Ihl apply? Does it apply only around the battlefield and around the conduct of hostilities, or does it apply in the whole region, even if most of the region is actually peaceful? When does it start to apply? And when does it end its protection? All these questions are paramount for the actual the humanitarian, for the victims, and they carry really big humanitarian consequences. Similarly, the Geneva Convention do not contain any definition of the prohibition they contain. Prohibition of torture, prohibition of rape, of outrages upon personal dignity. The ICTY was again the first tribunal to look closely at this definition, to explore the content of customary law, and to come up with definition for each of these offenses. Of course, the work of the tribunal has also shown the challenges that exist with the interpretation of some Ihl concepts, such as the concept of indiscriminate attack. When or in what circumstances would a particular weapon cause indiscriminate effect? Similarly, the tribunal judges have, to a certain extent, shown the difficulties of reaching a decision when we apply the concept of proportionality in an attack to the facts of the case. These findings have clearly shown that they are highly context-specific. So the RCRC actually embarked in 2011 on a project of updating the old Pictet commentary to the Geneva Conventions. These Pictet commentaries were published between 1952 and 1960. It was decided to produce an updated version of these commentaries, and that's what they look like these days, in order to take into account the developments in the law and the practice in the last 60 years, in order to provide an up-to-date interpretation of the Geneva Convention. And in this new publication that the RCRC produced last year, the formidable amount of case law of the ICTY in the last 20 years is hugely reflected in the definition of an international armed conflict in Article 2, obviously in the greatly enlarged text of Common Article 3, and in all the definitions of the crimes, the grave breaches crimes under the Geneva Convention. You will find the tremendous tribute of all the case law of the ICTY. So in two words, really, the tribunal breathed life into the GCs and the laws of armed conflict. And they breathed life into a branch of the law that was, in fact, in the past, fairly poorly enforced before the creation of those tribunals. And as I've got only 2 minutes left, and my second question was, and I won't have time to go into much detail, let me just say that next to the actually huge contribution in terms of the reaffirmation and the clarification of Ihl, the ICTY legacy and its impact has been huge on the enforcement of Ihl in general. enforcement at the international level, as the ICTY acted really as a blueprint for the creation of a great number of international judicial mechanisms. Everybody would agree that Article 8 of the ICC Statute would look very different these days if the ICTY hadn't successfully prosecuted the first few cases. We would certainly not have, or not that many, war crimes applicable in non-international armed conflict. It has been cited by distinguished speaker earlier. The ICTY work and successful conduct of hundreds of prosecutions have also participated in the creations of many hybrid courts. But, and I guess it'll be my last sentence if I'll be cut off before, the impact of the ICTY on the enforcement of Ihl is extremely important as far as national prosecution at the national level. It has completely revived the grave breaches regime that is contained in the Geneva Conventions. States have looked at their legislations. They have polished, if I can say, their criminal legislations. They've included in the last 20 years, there's a huge amount of new pieces of implementing legislation, making sure that they can extend the possibility for prosecution to take place. And they didn't only looked at the national legislation. We found more than 125 states have appropriate legislation enabling them to prosecute war crimes, but they've also put this into practice much more than before. This amount of the national enforcement, both at the international level but also at the national level through national prosecutions of states that have had conflict in their, on their territory, but also on the basis of universal jurisdiction, has clearly helped in further clarifying of Ihl and to a greater understanding of this concept of law.
Thank you very much, and thank you for an incredibly rich presentation kept within my dictatorial time limit. So thanks very much for that. We're going to move from, and I'm sure there will be an opportunity to expand on that in the question and answer period. We're going to move from this sort of broad look at the impact on law to another aspect of the ICTY's normative legacy, and that is the contribution towards the establishment of legal institutions. And there's probably none more appropriate to focus on and more significant than the establishment of the War Crimes Chamber of the Court of Bosnia and Herzegovina. We can learn much from this hybrid court, especially going forward. So, Judge, can you tell us about this chamber based on your experience, with particular emphasis on the ICTY's contribution and the relationship between the chamber and the tribunal? Judge.
Thank you. It's really difficult to speak about the relationship between ICTY and a national court within such a short time, but I'd like to say that the case law of the ICTY has affected the development of national legislation in many ways. There's no doubt that ICTY has contributed greatly to global justice as well as national justice and the fight against impunity. When speaking about the relationship between the Court of Bosnia-Herzegovina and ICTY, the first contact dates back to 1996. The Rome Agreement, where the rules of the road were established with controlled arrests and rules that allowed deprivation of liberty of specific individuals. This imposed an obligation for the prosecutors to submit documents to ICTY's tribunal to see whether elements are contained. This was completed earlier. Then there was a decision whether sensitivities of the case leave the competence with the prosecutor of Bosnia-Herzegovina. Joint conclusions adopted in 2003 by the Office of the High Representative and ICTY, thinking that a specialized chamber would be the best mechanism to prosecute the most sensitive war crimes cases, including those prosecuted by ICTY. The chamber started to work in 2005. The successes of the Court of Bosnia and Herzegovina are largely owing to the support of the international community, including ICTY. This was reflected in the presence of international judges who were part of the work of the War Crimes Chamber. This ended in December 2012, and international judges were superb experts in international law, including ICTY's cases. Some of them, in fact, served as ICTY judges, and their presence in the work of the court until 2012 helped build public confidence in the court, as well as understanding the ethnic impartiality in their rulings. This was the first national court. The ICTY deferred cases to under Rule 11 bis, provided indictments have been conferred. From 2005 until 2010, 6 cases were deferred from ICTY with a total of 10 indictees. All these cases were completed effectively within reasonable time, and no breaches of fair trial provisions were ever noted. In December 2008, the Council of Ministers adopted its strategy for prosecuting war crimes, decisions on the level of complexity, and the criteria for assigning cases to the Court of Bosnia-Herzegovina. This was largely based on the jurisprudence of ICTY. This was not completed within the 7-year time limit, and changes and amendments to the strategy are currently underway. The organizational structure of the Court of Bosnia and Herzegovina largely reflects the organizational structure of ICTY, starting from the establishment of the registry, incorporated in the national legal framework, subdivision of the registry, witness support unit, legal department, public relations, and translation interpretation services. The legal department includes lawyers supporting the work of the judges and trial procedures the same way it is done in ICTY. Translation interpretation was particularly important while we had international judges. Today it's important because all the rulings, particularly those in relation to war crimes, are translated and published at the website of the court. This was the first court in the region that established a witness support unit following the example of ICTY. This includes witnesses for the prosecution and for the defense. This is a service provided by the court. Following the example of ICTY, the court also allows communities to have access to the work of the court. We also have an outreach department allowing us to collaborate with different organizations and individuals and helping them learn about the work of the court. The legacy of ICTY is important for victims. It's important that facts about events are accessible in the languages of the peoples of Bosnia-Herzegovina, but also facts reliable historically. That is why the information center agreement was important in the City Hall of Sarajevo. This will allow access to all the information relevant for ICTY's trials. When we speak about the normative aspect, in that normative aspect, the aspect of development of jurisprudence of the state court, and procedural aspect. These are the 3 important elements. The first one, the normative one, is very important because everybody knows more or less that in Bosnia-Herzegovina, new criminal legislation was adopted in 2003. This criminal code prescribed a new offense that hadn't existed before that the criminal legislation applicable in the time of commission should be applied. But this was crime against humanity. There was a new provision. This introduction of the new crime, in fact, allowed for prosecution of a number of perpetrators that otherwise would not have been prosecuted, with the sole application of the old Yugoslav criminal code. Numerous rulings of this court, as well as European Court of Human Rights, confirmed judgments by the Court of Bosnia-Herzegovina within the legal framework prescribed by the Criminal Code adopted in 2003. The normative aspect also includes legislation regarding deferral of cases and the possibility of using evidence and facts established previously by ICTY. Thus, the law on deferring ICTY cases to the prosecutor of Bosnia-Herzegovina and the use of evidence prepared by ICTY in cases before courts in Bosnia-Herzegovina, and the law on protection of vulnerable witnesses. That's why it's important to know the regulation of command responsibility as a novelty in the 2003 Criminal Code. This allowed for not only perpetrators to be prosecuted and sanctioned, but also for their superiors officers to be prosecuted and sanctioned. Relevant aspects of the legacy are also reflected in the jurisprudence of ICTY that also influenced the jurisprudence of the Court of Bosnia and Herzegovina. In many of its cases, the Court of Bosnia-Herzegovina followed the jurisprudence and the case laws such as determination of command responsibility, the jury and de facto command responsibility, joint criminal enterprise as one of the forms of commission of the crime. This doctrine was totally new to the national legal framework. Also, the customary law as applied by ICTY, especially for confirmation of general elements of crime, elements of crimes against humanity, determination of widespread systematic attacks using customary law, various types of premeditation, analyzing instruments that were used in its commission, etc. I've already noted this aspect of deferring cases to the state prosecutor by ICTY to be prosecuted before the Court of Bosnia-Herzegovina, which was a novelty starting from 2004. When it comes to the law on protection of vulnerable witnesses, this, in fact, was related to Rule 75A. This law gave the possibility to secure privacy and safety of witnesses who may be exposed to different types of very dangerous pressure. Thus, national legislation established rules following the example of cases conducted before ICTY. If we analyze measures of protection secured for witnesses, the measures are identical to those applied by ICTY. The third aspect, finally, related to the way proceedings are conducted in war crimes cases. Let me say that following the example of ICTY, the court introduced status conferences before the trial. Various procedural technical issues are considered so that the actual trial becomes as effective as possible, and then to also anticipate various problems that may appear. I've already mentioned legislation on deferring cases, also accepting res judicata as an important element that the court is now using, especially when it comes to cases already tried and adjudicated before ICTY. And by way of conclusion, on the basis of this, let me say that the importance of ICTY's legacy is evident in the case of the Court of Bosnia-Herzegovina. The contribution has been to help us deal with cases of war crimes and also using rules in the strategy 2005-2017. We've completed 175 cases, 265 persons, of whom 74 have been acquitted. However, a huge amount of work lies ahead. Effective completion of these cases leads us to the actual purpose of criminal proceedings, but also the process of confronting the past. Thank you very much. This is what I wanted to say on this occasion.
Thank you very much, Judge, for an amazing conveying of the sense of the important work of the War Crimes Chamber, and I'm sure there will be questions from the audience on the various points which you raised. Let me now turn to Jennifer. Jennifer, obviously we want to look not only at the legacy, but we want to look at measuring the legacy. And so one of the areas that you've written on and worked in is the question of benchmarking. So can you speak a bit about benchmarking of ICTY legacy and tribunals in general?
Great.
Thanks.
Thank you. It's a great pleasure to be here. I'm making these remarks based on a paper I've co-written with my colleague Eva Vukusic. So I think we're here to talk about the ICTY's legacy, and I think we have to first say, well, how would we measure this, and what do we expect a tribunal to achieve? Because I think for all of our tribunals, as we go forward in this field, this is something we need to keep in sight. So if we go back to the UN Security Council resolution creating the ICTY, it recites the ICTY will bring justice, contribute to the restoration and maintenance of peace, and contribute to ensuring violations are halted. So deterrence, not the ICTY resolution, but the sister tribunal ICTR's resolution says it will create reconciliation. So obviously justice is a key benchmark. We see here, of course, the ICTY with significant accomplishments, 161 indictments, all original indictees apprehended. Of course, there will be disappointment. This is clearly not all the perpetrators by any measure, which is why it's so significant that we see 3 levels of justice, the ICTY, the hybrid, and then the local courts. There is still so much remaining to be done. Yet, with a little bit of comparative perspective, we see our other tribunals do nowhere near this much. Unfortunately, and it's often an issue of funding, and how it is chosen to staff these and create these. Significant tribunals, but the Sierra Leone Special Court prosecuted 9 very high level from all sides in the conflict, but 9 only. The extraordinary chambers of the courts in Cambodia, for 1.9 million fatalities by the Khmer Rouge, is on its 2nd trial involving 2 accused. Its first trial involved 1 accused, and it is unclear whether it will go on to trials 3 and 4. The International Criminal Court, as it was designed, prosecutes only a few in each situation countries because we know it has a very busy docket. So we have to reflect the ICTY as the high watermark in terms of our tribunals to date. Our closest comparable would be the ICTR with 93 indicted, but 8 still at large. Clearly, in terms of prosecutorial accomplishments, and I'm sure there will be further reflection, Eve has already discussed, there is now a massive body of well-reasoned jurisprudence. So we have the parameters of genocide, war crimes, crimes against humanity, individual command responsibility. This is our first huge comprehensive compilation of this that is a tremendous legacy as we go forward. We have prosecutions of high-level perpetrators, grave crime scenes, some perhaps jurisprudential low points we might acknowledge. In a couple acquittals, I understand any tribunal can have acquittals, but there's some I might be particularly critical of. We have certainly prosecution of underreported and underprosecuted crimes at the ICTY. Witnesses and victims felt sufficiently protected to come forward. These are all incredibly significant, as well as the observance of fair trial procedures. On the other hand, I think we get into shakier territory when we look for tribunals to accomplish much more transformative benchmarks, that they go beyond this judicial capacity. They can, but it's more complex here. So if we look, has the ICTY contributed in terms of a truth-telling function or contributing to the historical record? Obviously, it has greatly. We have cases with solid evidentiary databases backed up by forensic evidence. We have a large database of documentary evidence, proceedings one can watch on video. Yet, As you look in the region, you see different narratives being offered. We have denial of crimes, partial denial of crimes, and Serge mentioned the glorification of war criminals. So what the ICTY has done has unfortunately not entirely changed this. I don't blame the ICTY Outreach Office. I think they've done tremendous work. This was a very challenging climate, and we have to be honest. An outreach office can't necessarily change nationalistic rhetoric. There will be some who will never be persuaded of the work. So I think what we say is the ICTY has narrowed the space for denial. Now, if we look at the findings from Nuremberg, we see that the German people were not persuaded of the merits of the Nuremberg Tribunal in the years immediately following. And it took really decades for this to turn around. So perhaps in the future, we will have a different perspective, future generations. On the other hand, future generations don't always bring new attitudes. And I look with concern at programs such as 2 schools under 1 roof, or what parents teach younger generations. So we have to be cautious. It's good to be optimistic about the youth, but there are concerns. In terms of the contribution to peace, so first I want to say that I think this is in the forming resolution because this is triggering Chapter 7. This is something of formulaic language that the Security Council is operating under Chapter 7 and therefore is acting to contribute to international peace and security. It is unclear whether tribunals can always yield peace dividends. Here, I do think the ICTY has, by helping marginalize high-level perpetrators through indictments and driving them off political and military stages, has proved a key function. It's very hard to measure this peace dividend, and I know sometimes it's a challenge with donors to explain these kind of non-judicial contributions. It's hard to quantify these. Not all tribunals do this, and I don't know that we can always sell that tribunals contribute to this. Certainly, they contribute to rule of law. So one has to be cautious. In terms of reconciliation, and I think this was already alluded to, tribunals don't reconcile people, so we shouldn't make these claims. In the short run, they potentially could exacerbate tensions, yet they are critical because I think without the foundation of prosecutions, we wouldn't even talk reconciliation. So no, they don't do it, but they're crucial. And we'll later have a side event with PCRC, and we'll talk more about reconciliation and grassroots efforts in this respect. In terms of deterrence, the resolution said it would create deterrence. I think it's very hard to show. In the early years, the war is still raging in the former Yugoslavia. Clearly, perpetrators do not seem to have been deterred. Of course, if there was deterrence, it's very hard to measuring a negative of something that did not happen. On the global level, we are starting to see a deterrent effect of the tribunals, but it's only nascent. So we see after the International Criminal Court's verdict in the Thomas Lubanga case that some child soldier units are disbanded. We see indications that commanders understand the concept of command responsibility. This is crucial, but unfortunately, if we look at Syria today, we know global deterrence isn't there. We have so much more to do in this respect, and it's understandable because unfortunately there are whole parts of the globe without jurisdiction. There are not tribunals in many parts of the globe. The International Criminal Court doesn't have jurisdiction in key parts, so it is a challenge for the future to create more tribunals, more universal jurisdiction, more states to join the ICC, so we have a more global deterrent effect. In the meanwhile, we have to be cautious about our claims. We're going to have trials and people will be deterred. It depends on many factors, such as how many the tribunal will prosecute, whether the suspects can be or there's reasonable likelihood of apprehension, and whether the tribunal is seen as effective and credible. So I realize some in the region are disappointed at the ICTY's work, and this is perhaps because we have harnessed a lot of expectations on the shoulders of what is a tribunal. Tribunals are first and foremost courts. That is their prime function, is rendering justice. As we move forward in this field, particularly as the ICC goes into so many situation countries, it's important that we manage these expectations and not oversell what we can claim of tribunals. Thank you.
Well, thank you very much, Jennifer. I think there are a number of points in there that each of which could be the subject of a lengthy discussion, and hopefully we will have more time, and also you will have the benefit of reading Jennifer's work on this and all the interesting points that she's identified on benchmarking. Last but certainly not least, when we're talking in the realm of unexpected legacy, we're talking now about the unexpected of the unexpected, I would say. So Mark is going to speak to us about some of the remarkable effects, legacy of the ICTY in national jurisdictions, including the United States, and he's going to give us some examples of that spin-off effect that I don't think anyone anticipated in the early days of the ICTY. So Mark, over to you.
Great, thank you. So good morning, everyone. It's great to be here with friends and make new friends and enjoy the sun in beautiful Sarajevo. So as Kim said, I'm going to talk about a very different kind of story. I think a story about legacies that involve a little bit of wandering, movement between places and spaces. And as a legal academic, the kind of movement that I find interesting, which isn't only geographic, but also movement between and among legal categories. So what I want to talk about is the ICTY's legacy in domestic civil litigation, remedies in tort and delict for atrocity crimes, with the United States as a case study. And then I want to talk a little bit about the ICTY's contribution to customary international law, this amorphous entity we don't really know how to measure. And then finally, I'd like to quickly touch upon, tying everything together, the ICTY's contribution to remedies to atrocity other than the criminal law. So let me move you back in time to 1789, and let me move you to the United States. And in 1789, the first Congress of the United States passed a statute called the Alien Tort Statute. And this was designed to create civil damage remedies, money remedies, in tort for violations of the laws of nations, which American judges have understood to mean customary international law. This remained largely dormant for 200 years. And starting in the late 1970s, human rights activists seized upon this particular statute to file claims for atrocity crimes in United States courts of general jurisdiction. Many claims have been brought. First, they targeted principal perpetrators, and then later on targeted corporate entities for aiding and abetting principal perpetrators. These claims are controversial. There's many jurisdictional concerns. I don't want to talk about that. What I want to talk about is the fact that this statute gives United States judges of general jurisdiction the ability to determine the content of customary international law is a harm, the kind of harm that constitutes a customary international law violation. And in this regard, this statute is a laboratory of sorts, a petri dish to determine what custom is. So here's where the ICTY comes in. What is it that United States judges of general jurisdiction look to determine whether or not a violent act constitutes an infringement of international custom? And here, the statutes and the case law of the international criminal courts and tribunals serve as appearing modestly, but with some routine and regularity in the determinations by U.S. judges as to what international custom is. Among all the international courts and tribunals, the ICTY appears the most frequently in terms of citations as, quote, authoritative evidence of the content of customary international law. For what specific points? First, aiding and abetting, in particular, the knowledge requirement. Secondly, on questions of corporate liability, namely, can corporations be sued for atrocity crime violations in tort? And thirdly, for the definitions of international crimes, in particular, genocide and crimes against humanity, notably persecution. Having surveyed this particular case law, studied it, coded some of it, I'm left with a couple of interesting observations. First, there's tremendous judicial opportunism that occurs. Different judges will turn to the same work product of the international tribunals and arrive at fundamentally different outcomes as to whether or not something actually reflects custom or how that might actually be operationalized. And for a common law lawyer, which is what I am, I find this particularly vexing in the sense that it actually reflects, I think, one of the foibles of the common law, namely a sense of opportunism in looking to the kind of precedent you want to achieve the outcome that you wish, whether that is an activist outcome or an outcome that may very well find that there's no corporate liability under the Alien Tort Statute for corporations, for which the ICTY's absence of jurisdiction over corporations has actually been cited at times by some judges. Another important takeaway for me on this is the following, and I'd be curious, Judge, for your thoughts on this. What's the role of a national judge when that national judge has to apply or interpret international law? International law strives to be universal, so is it okay if an international legal concept is applied differently within different national legal jurisdictions? Can you have comparative differences in the application of international law? What's the role of a judge? Is it to enforce, create, or in some instances deny? And are those questions different when it comes to applying international law than when it comes to applying national constitutional law or national private law? And finally, you won't even have to show me, because I'm going to end early, because I don't know why, I just will. Finally, and to me the most interesting, I have long written about my skepticism of the criminal law as a tool of social reconstruction following atrocity. And I agree with a lot of what Jennifer had to say about the limited space of criminal law in this particular frame. And I have long argued that there has to be an expansion of remedy, a diversification of remedy. We need so much more than courtrooms and jailhouses. And the more courtrooms and the more jailhouses we build, the less, I worry, the less we think about other methods of justice. And I have therefore found it particularly heartening and interesting that the case law of the ICTY, its constitutive elements, and its jurisprudence have actually wandered, migrated, moved. Some might say drifted, but I would prefer a more sort of positive vocabulary, have wandered into a very, very different sphere of law. And at the end of the day, for me, what I find heartening is maybe there's a story to tell about the ICTY's legacy that is beyond criminal law and is beyond any one particular place. And if the case law and the statutory elements of the ICTY can cross an ocean, cross the world, and inform methods of justice that don't involve sentencing, penalization, imprisonment, guilt, or innocence, then I think that's a really neat story to tell, here, there, or anywhere. Thanks for your time.
Well, Mark, thank you very much for some fascinating reflections there. It would be very interesting to know if we see that phenomena elsewhere and to have that discussion. We have, I imagine, a very limited time. We're already running into the coffee, and I know how dangerous that is for the health of the panelists. But I do think with this rich panel that it would be very useful to take a couple of questions. So if I can start at the very back of the room.
Dobro jutro, dobar dan svima.
Good morning to everyone. My name is Hasan Nuhanovic. I survived all the events in Srebrenica in 1995. First of all, I would like to welcome everyone. I would like to greet all those present who have found the time to attend this important event. I don't know how much the public in Bosnia and Herzegovina is aware of it, but as far as I know, this is the last time that we're going to talk with people who are representing the International Criminal Tribunal for the former Yugoslavia, the ICTY. The public here, the entire country, should use this opportunity to hear from you who represent the tribunal some information that was not available to date, maybe for some explanations. Of course, the mechanism will remain behind, and I hear that the mechanism will be working for the next 5 years, that is the term of its mandate. I would like to ask a specific question. I would like to thank the tribunal, first of all, for its work. I have done that before. The tribunal was the only hope to us here who have survived terrible atrocities, including genocide, that at least sliver of justice will be achieved. At the moment of perpetration of the crimes, we were aware that justice, the way we would imagine absolute justice to be, will never be achieved. What kind of justice, in any case, can restore the life we had before the war, the dead? Justice that could be attained is a relative kind of justice. This is legal court justice that you are offering us. I understand that. You spoke about deterrence. It's an important concept. In our language, it is interpreted as odvraćanje. And somebody at the panel mentioned the wartime period when the tribunal was established as a tool of deterrence from the commission of future crimes that could have taken place. And you said that the tribunal could not implement that objective. In 1993, is when the tribunal was established. The first indictment was for Vlasenica, for the Sušica camp, which is where I'm from. General Mladić was indicted for the first time much later. I don't want to be a know-it-all here. I want to ask, what happened had General Mladić been indicted before Srebrenica instead of after Srebrenica? And then we can talk about deterrence. If we talk about it from the perspective that we have now, it doesn't make much sense. Deterrence still as a term is very important as far as the tribunal is concerned. Deterrence after the war. What did the tribunal deter people from in the region? I think that one of the more important roles of the tribunal was to prevent retribution. This is a country where genocide and other horrible crimes have taken place. This is something that deserves further research. I don't know if this has already been done. I don't know of any case of retribution on any side. This did not happen for a number of reasons. Perhaps there are cultural reasons for that, a question of mentality. I didn't go into that, but I think the tribunal is one of the reasons that there were no retributions in this area. So it did have a kind of deterrence role because it stopped people from taking justice into their own hands, because we placed all our hopes with the Hague. And no matter how long the proceedings lasted, the rage that anybody had in the beginning decreased over time. Please don't think that we're still not angry, but these manifestations, if they're not shown in society, we cannot discuss them. So There was nothing of that destructive kind here. Yes, I see that you're warning me. I'm going to finish soon. But you did have that positive role. The last speaker spoke about the aspect of reparations. There has been nothing from that topic. Before that, people talked about how a man sat in an airplane for the first time. Many of them went to the tribunal and left the country for the first time. They went to a place where they never thought they would find themselves. They knew where they were going, but these people came back to Republika Srpska as Bosnians, and the tribunal forgot them once they came back. A person went to the tribunal, they came back to their area, to the neighborhood where there were killers against whom he went to testify in the first place. I would like to end here, and I would like to thank you on my own behalf for everything you have done for you and for us, because this is a crime of universal jurisdiction. It's not just a question of Bosnia and Herzegovina. My question is that in this way you actually protected the world and yourself. Thank you.
Thank you for your comments, and I would like to emphasize that of course we do want to hear from this audience, and you will have an opportunity even post this conference to contribute to this dialogue by way of communications by email and contributions. So thank you for those comments. I'm afraid that we are very limited, so I'm just going to take one more question, and I hope it could be a brief question, please, and then I'll see if there's any reactions from the panel to the two questions. Thank you. Right there.
My question is for Professor Drumble. The point you made at the end I thought was a really excellent one and a really important one, that we cannot over-rely on any criminal tribunal. And I think one of the major problems here, as in many countries, is that people expected too much from the Hague Tribunal. So I think that managing those expectations from the outset is absolutely crucial. And Alex Baren, who was involved in South Africa's Truth and Reconciliation Commission, talked about the need for a holistic approach to transitional justice that isn't simply about criminal courts, but it's about Truth and Reconciliation Commissions, it's about memorials and so on. So my question, Professor, is simply in terms of a holistic approach to transitional justice in Bosnia-Herzegovina and more broadly in the former Yugoslavia, what do you think we need and what do you think is currently missing? Thank you.
Thank you very much. If I could ask, perhaps Mark, you could start by answering that particular point, and then if there are any comments from the panel generally on the questions of deterrence that were raised, we can take those. Thank you.
So thanks for the question. I think one point that was already raised by the gentleman in the corner is a reparative point, and I think that's often of crucial importance in this particular context. But I guess I would answer your question by saying that what is missing is often what has not yet happened, right? And I think when we think of things that are missing, we shouldn't necessarily think of things that are lost, but we should think of opportunities that have not yet been fully developed. And it could be that some of this is a sequencing movement, right? There was a lot of confluence of circumstance internationally to build courtrooms and jailhouses to try to deal with atrocity. I mean, international criminal lawyers are always seeing their work as this battle against state sovereignty and against state influence, and that's true. But states have rallied to build a small number of courtrooms and hold a small number of trials as, I have argued, sort of their vision of the first best instantiation of justice. So I guess my answer to your question is what is missing may be what has not yet happened, but things may not have happened because places may not have been ready for them. Now that the ICTY is winding down its work, I guess what I would say is maybe by looking for these unanticipated legacies in different places, conversations can be catalyzed to do much more in this particular regard, and perhaps reparative justice, perhaps a broader officialization of memory could play a key role, and how one arrives at that may incorporate, in some instances, the work of the ICTY. And on this, let me add with one final point. I did find one United States case that involved litigation in the former Yugoslavia under the Alien Tort Statute. And it was interesting to me because the judge in that case actually relied on an ICTY judgment as indicating the official story of the violence as it occurred in this particular part of the world, which I found was in many ways a naive move, because it's not clear to me that there is any officialized narrative, but in some senses also shows the power and authentication of judgment. But wait, if I had a specific answer, I wouldn't be sitting here, right? I'd be probably somewhere else trying to like sell my specific answer. So there you go.
Jennifer?
Thanks. I'll just try to briefly respond to Hasan Nihanovic, who I recognize from Sense News videos. He gave us the important reminder that justice is always our second best. Prevention of the crimes in the first place is critical, and there's so much more the international community has to do in this respect. Yes, I agree. I don't know that we've seen the deterrence effect in ICTY, and we're struggling globally to do this. There is so much more to be done, but I think as there's more and more tribunals, more and more sense by perpetrators, there are multiple ways that jurisdiction can be obtained over them. We are starting to see some effects. We are seeing anecdotes of commanders lecturing their troops not to commit crimes because they get the notion of command responsibility. That's an instance from Afghanistan, a commander reciting a Human Rights Watch report of troop crimes and saying, don't commit these, I will execute you if you do. But I think he got, which is not the Human Rights Watch message, I'm ex-Human Rights Watch, but he got the idea of command responsibility. Reparations, no, the ICTY wasn't set up to do reparations. Our new tribunals, the ICC has some reparations capacity, ICTY wasn't, and ICTY wasn't doing the whole transitional justice bailiwick. There's so much more to be done in terms of reparations and memorialization and other transitional justice tools, and this has to be owned in the former Yugoslavia. So.
Thanks very much, Jennifer. And Judge, I will give you the last word for this panel.
I really think I should say a few things about deterrence. It's a complex issue. Perhaps we should have more time in order to give a reasonable answer. But to be very brief, criminal proceedings have as their aim individual deterrence. At the same time, general prevention has a general message for every potential perpetrator about what awaits them if they commit certain acts. That is why sanctions are very important. I know that Geneva Conventions do not concern themselves with effective sanctions. However, what is happening now in Bosnia and Herzegovina is very interesting. That's why I spoke about the parallel application of two sets of legislation, of former Yugoslavia and of Bosnia and Herzegovina. They have two different ideas and two different ranges of criminal sanctions. So, when speaking about decision of Judge Maktouf, I have to say that the Constitutional Court applied the criteria from the aforementioned case, and it was not clear whether those criteria could be applied in other cases before the Constitutional Court, which had to decide on general issues of the application of law. The court decided to apply this in all the cases, including the genocide cases. So, according to the Constitutional Court decision, Now we have the War Crimes Court applying the maximum criminal sanction of 20 years imprisonment for genocide, while at the other end of the scale, we have the possibility of 45 years of imprisonment for some other particular ordinary crimes. So take a look at this paradox. We have two sets of criteria. And how can you then impose an adequate penalty that will lead to an adequate deterrence? Most recently, I have noticed that some chambers in Bosnia-Herzegovina imposed the maximum term of imprisonment of 20 years, even in cases of international criminal law. Then, the issue of reparations. It's a very important issue. And the Court of Bosnia-Herzegovina is the only court that imposed reparations on perpetrators. As far as I know, no other court has ever reached such a decision. Of course, some people might be rather critical towards it, but I think that the time will show whether this was an adequate response or not. In any case, reparations are more in the purview of states than courts.
Judge, if I could thank you very much, and thank you, and ask you all to join me in thanking the panelists, and we will now move to the coffee break.
Hvala vam svima. Sutra ćemo imati i panel koji je posvećen drugim temama. Biće puno panela, biće puno prilike da čujemo i vaš glas. A sada moramo, pošto kasnimo sa programom, moramo da skratimo. Imaćemo kafe pauzu kraću od 20 minuta, dole niz stepenice. Tu možete da se poslužite. Hvala vam. Thank you very much. We will have a short coffee break.